So a lot of people are getting confused on how to administrate the dispute process when you are trying to remove a auto loan from your consumer report. It's very important to make sure that you are using the right words. It's very important to make sure that you are referencing to the right laws, and you got to know who to send it to. So there are some key things that you need to know about when you are going about your dispute and getting this auto loan removed from your consumer report. The first thing you want to do is make sure that you do not give up on yourself. And the reason why I say that is because a lot of people give up during the dispute process. They give up because these institutions will try to test you. They will send you everything but what you ask for, okay? If you ask them for disclosure forms, they're going to send you a contract or they're going to send you a payment history. That doesn't mean that the information has been verified. They still have not sent you what you ask for, okay? So do not give up on yourself, because these people will definitely try to test your knowledge. So another thing you want to make sure that you're doing is sending out your mail certified mail green return receipt. That is so important. You don't want to just send your regular mail, because these people can easily say, hey, we didn't get your letter, we don't know what you're talking about. So you want to make sure that you are tracking your information. So another thing people are doing is they're sending too many disputes out within the same month, okay, about the same account. If you're sending a dispute out about your auto loan, that's one account. You only want to dispute only one time about that account within that 30-day time frame. So like if you send a dispute letter on the 15th, you don't want to send another letter out on the 26th. It's just going to prolong the process. You have to give them 30 days to respond. So if you send another letter out, that's going to allow them to take 45 days just to send you back a response and get on top of it. Okay, so you don't want to do that. It's going to prolong the process. Only send one dispute per account within that time frame, that 30-day time frame is very important. When you are trying to delete an auto loan from your consumer report, there are certain acts you want to make sure that you speak on. One important act you want to make sure that you include is the Gramm-Leach-Bliley Act. You can find that on the FTC website, okay? And the Gramm-Leach-Bliley Act is an act of protection that protects the consumer from unfair practices of financial institutions. So they protect you from unfair practices. So before this act came out, institutions was doing whatever they wanted to do with consumers' personal information, their non-public personal information. So this is why this act came about November 12th, 1999. So it's very important to get familiar with that act and Google that act, and you want to make sure that you include that in your dispute letter. This particular act is very vital to including in your dispute letter. I can't say it no more than that. Like, you want to make sure you include this act. It's called the Gramm-Leach-Bliley Act, okay? And you can find it on the Federal Trade Commission website. It's a government website. These are government laws. This is not no information I'm making up or no he say, she say information. These are federal laws. Any institution that you are doing business with have to follow this act, okay? They have to follow the law. I'm talking about whether it's your mortgage contract, your phone bill, your auto loan, whatever. They have to follow these acts, okay? They have to follow them. Anybody that you are in contract with, if they're an institution, they must follow these acts. And this is why it's important to know your laws so you can hold them accountable. So when you are writing your letter, you can let them know, hey, I know all about the Gramm-Leach-Bliley Act, okay? And I am putting you up on notice. This is why it's so important to understand the laws and know the laws, because if you understand the law, it's easier for you to go about explaining to them how you was violated. If you don't read the law and you don't know what the law means, how can you explain to them what they've done wrong? Another code I want to make sure that I bring up is the 15 USC 6802, obligations with respect to disclose of personal information. This is another act that you want to make sure that you are putting in your letters. Okay, 6802, all you got to do is Google 15 USC 6802. It's obligations with respect to disclose of personal information. So with this act, there are 3 disclosure forms that they supposed to provide to you. The reason why this act is so important when you are trying to delete an auto loan from your consumer report is because when you left that dealership, they were supposed to provide you 3 disclosure forms, okay? The disclosure form 1 was telling you that we may disclose your information to a third-party company. If they say we may, that means that they may not, I would think, right? So if they may, then it must mean I may have a choice to say whether or not I want my information to be disclosed to a third-party company. The second disclosure form is them letting you know that you have the right to opt out. So you can say, yes, I want my information reported, or you can say, no, I don't want my information reported. The third disclosure form is them showing you exactly how you can exercise your rights of opting out. They supposed to explain all this clearly, okay? You should not leave no institution without them explaining to you clearly how to go about opting out. They supposed to give it to you in some type of electronic form, writing, something. If you didn't get that, then that's a violation. So this law had to be included in your letter when you are writing a dispute, because it tells them, hey, this is why I'm writing you, because I did not get these disclosure forms. So this contract is now void. It's no longer a contract that I got to abide by, because this contract was deceptive. This contract was misleading. This is what you got to let them know. This is a misleading contract. So I'm going to read you guys just a little of the deletion, the auto loan deletion letter, just a little bit of it, okay? Because there's some important information that should be a part of your notice when you put these people on notice, when you are trying to get your auto loan deleted, okay? I'm just going to read a little. If you fail to honor my request and discriminate against me for exercising my rights, that will be a clear violation under the law 15 USC 1681A3. So I want you guys to know it is very important that I use the word discrimination, okay? I put that word in there for a reason, okay? It's very important because the law says if they try to discriminate against you, that is a violation of the law. That is a violation. Some of these companies would try to discriminate against you just because you are activating your rights. Just because you are telling them, hey, you violated me and now this contract is no longer valid. They would try to shut down your account, freeze your account, close your credit cards, and that's all discrimination. There is a law that actually protects you from that. And you can use that act and put it in your letters. So that's why that discrimination, you want to make sure that you are putting that law and that act in your letters. And where you can find that particular act is the Department of Justice website. So we're going to go to the Department of Justice website and we're going to read a little. I want you guys to hear what I'm saying. You want to make sure that you're adding this stuff in your letters when you are trying to get a auto loan deletion. Okay? So the Department of Justice website is a government website, guys. A government website. So it says the Equal Credit Opportunity. So it says the Equal Credit Opportunity Act is 15 USC 1691 prohibits creditors from discriminating against credit applicants on the basis of race, color, religion, national origin, sex, marital status, age, because an applicant receives income from a public assistance program. I'm going to talk about that one. That is a really big one because you receive, public assistance. People would discriminate against you as well. And that's against your rights. That's the law said they can't do that. Or because an applicant has in good faith exercised any right under the Consumer Credit Protection Act. Now, that's what we're talking about right here. Or because an applicant has in good faith exercised any right under the Consumer Credit Protection Act. I exercise my rights. Now you want to discriminate against me. Okay. That is a violation, y'all. It's a clear violation. So when you know the acts and understand where the violations has taken place, you can show them where they're going wrong. It's not about you coming up with your own words. That's why I said in the beginning, you got to be very clear with your words. Your dispute letter should include their words. The majority of your dispute letter should have the words of the law. It shouldn't be having no made up language. They don't speak the language that we speak. You got to speak legal language. And that's why it's important to make sure that you are referencing to the right law. So you want to add this law in there, discrimination, the Equal Credit Opportunity Act. It's very important, okay? So the same way I'm going about breaking the codes down, reading over them, and showing you how they violated you is the same way you will go about explaining in your dispute letter. You would do it the same way. You would talk to them just like how we're talking or how I'm talking to you, and you explain that in your dispute letter. When you went to them institutions and signed them documents, they locked you into a contract and told you that you must follow all the terms and conditions of the contract. After understanding your rights and learning the laws, you know that the contract you signed is misleading and deceptive. They gave you a deceptive form. It's lies. You deceived me. So as I said before, you want to make sure that you certify your mail, green return receipt, and you want to make sure that you get it notarized. This is very important. Now, I got a lot of people that have asked me, what if they don't accept my disputes? This is very important, okay? Let me explain something to you. You want to make sure that you mail all your dispute letters. You do not want to dispute online. You do not want to fax nothing. You don't want to be calling nobody over the phone. Court starts in the mail, okay? You want to administrate your process the right way. And in order for you to get the remedy that you desire, you want to make sure that you are mailing your disputes. Okay, getting your documents notarized is so important. Okay, notary is an important tool when it comes to legal standing. Notary is very powerful. Okay, very powerful, and I'm going to explain why. So once a document is notarized, it's no longer a regular document. It's a legal document that is now a contract set in place with you and the institution. So now you didn't put your own contract in place. So it's not about whether or not they're going to accept your letter or not. That don't even mean nothing when it comes to legal standing. That's why it's important to make sure that you are notarizing things and you understand your laws. Now they must follow all the terms and conditions that you have set in place in your dispute letter, which is now in the form of a contract. You see how powerful that is? That's why notary is so important. And this is why it's so important to make sure that you are mailing your documents out, reading the correct laws and inserting them in your letters. Now you got a contract in place with you and that institution. It's not about whether or not they're going to accept it. They got to accept it because now that's a legal document. That's how powerful it is. That's how powerful it is. It's now a legal matter and they must follow the contract. That's it. That's all. It's plain and simple. Administrate the right process. Learn the laws. I just broke down exactly how you need to delete a auto loan from your consumer report. You want to make sure that you are referencing to the right laws, okay? As we talked about, 6802, the Gramm-Leach-Bliley Act, and you also want to make sure that you're including discrimination. If you try to discriminate against me because I am acting on my rights, then that's a violation too, okay? So you can get them from all different angles. This is how you get the remedy that you want. This is how you remove this information off your consumer report. Making sure that you are putting the right people up on notice. We're not sending it to the consumer reporting agencies, Equifax, TransUnion, and Experian. We are sending this notice to the institution that you had done business with, okay? Put them up on notice. So I have the auto deletion letter in my bio. If you want to delete your auto, if you want to take back your power, you can do so. You don't have to wait and accept what these people are saying because the contracts that are set in place is not valid. It is not the truth. It is all deceptive. And the law speaks on that. So if you have an auto loan that you are trying to delete, click the link in the bio or look in the description of this video and you can get the auto deletion letter. You do not have to wait. You can take back your power. You can let these people know what it is and you can get that auto loan deleted off your consumer report. It shouldn't be there. We got to learn the laws. If we learn the laws, y'all, you'll realize that everything on your consumer report you can have removed. It does not have to be there. Whatever you want reporting on your consumer report is what you want reporting. Whatever you want removed, you have to say so to remove it, okay? It's that simple. So click the link in the bio, get the auto deletion letter, and don't wait to be great.